Welcome back to US Visa News Hub. I am Mr. Burhan. A couple of weeks ago, we covered the basics of the Blanche versus Lau decision, the Supreme Court case that changed how green card holders are treated at the border. Today, I want to go deeper because there are several details in this ruling that most videos are skipping over, details that could directly affect you, even if you think this case does not apply to your situation. Let's do a quick refresher first. On June 23, 2026, the Supreme Court ruled 6-3 in Blanche versus Lau, holding that border officers do not need clear and convincing evidence that a green card holder committed a disqualifying crime before treating that person as an applicant for admission rather than as someone already admitted. Justice Clarence Thomas wrote the majority opinion. The case itself involved Muk Choi Lau, a lawful permanent resident since 2007, who was paroled rather than admitted at JFK Airport in 2012, while a New Jersey trademark counterfeiting charge was pending against him. This video is for informational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your case. Here is what most people do not realize. This case is only about one narrow slice of a much bigger rule. Under immigration law, there are actually 6 separate exceptions that can cause a returning green card holder to be treated as an applicant for admission instead of a returning resident. These include abandoning your permanent resident status, being outside the United States for more than 180 days, committing a crime during your travel, leaving the US while in deportation or extradition proceedings, committing certain crimes in the US that make you inadmissible, and attempting to enter without inspection. Mr. Lau's case dealt specifically with exception number 5, involving a crime that could make someone inadmissible. Legal analysts widely expect the government to argue that the same lowered evidentiary standard from this ruling should now apply to the other 5 exceptions as well, which means this decision could eventually reach far beyond just criminal charges. Another detail worth knowing, the Supreme Court did not actually resolve everything in Mr. Lau's own case. The court sent one specific question back down to the lower courts on remand: whether trademark counterfeiting itself even legally qualifies as a crime involving moral turpitude in the first place. So even the person at the center of this landmark case does not yet have a final answer on his own situation, which shows just how fact-specific and unpredictable these determinations can be. There is also an employer-side consequence that almost nobody is talking about. If a green card holder is reclassified as an applicant for admission and placed on parole instead of being formally admitted, this can affect their documentation for employment purposes. According to guidance published by immigration law firms following the ruling, employees presenting temporary or parole-related documentation instead of a standard green card may require different tracking and re-verification procedures under Form I-9 rules. If you are an employer with lawful permanent resident employees who travel internationally, or if you are a green card holder who was placed on parole after a trip abroad, this is worth discussing with an immigration attorney or your HR department directly. Now let's talk about the dissent, because it tells you where this could be heading. Justice Ketanji Brown Jackson, joined by 2 other justices, warned that this ruling essentially hands the government sweeping authority to place lawful permanent residents into prolonged legal limbo based on nothing more than a pending, unproven accusation, without ever having to show real evidence at the moment they are stopped at the border. Critics have pointed out that during oral arguments, even Justice Alito questioned whether the government was asking for a far broader ruling than the facts of this specific case actually required. That tension between what was argued and what the court ultimately decided is part of why immigration attorneys expect this decision to be tested and expanded in future cases. So who does this actually affect right now? According to legal analysts covering the decision, the vast majority of green card holders with no criminal history at all are not affected by this ruling in any meaningful way. This is specifically relevant if you have a pending criminal charge, a past arrest tied to unresolved allegations, a prior conviction, or any conduct that could potentially be classified as a crime involving moral turpitude. Even something that felt minor or happened years ago and that you may not have thought about since. Immigration law defines what counts toward inadmissibility differently than the criminal justice system does. So something that seemed small in criminal court can carry much bigger immigration consequences than you'd expect. If any of this applies to you, here is the bottom line. Before you leave the United States for any international trip, speak with an immigration attorney and have your record reviewed. Do not wait until you are standing at the airport to find out where you actually stand under this new standard. If this deeper breakdown helped clarify things, give the video a like and subscribe to US Visa News Hub, because we will keep tracking how this decision gets applied and expanded in the months ahead. Thank you for watching. This video is for informational and educational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation.